Hello and welcome to everybody who's starting to join us. We are a few minutes off from beginning, so please sit tight and we will get started promptly at the top of the hour. Okay, everyone, let's get started. We have about 10 people in the room so far, and there are more on the way. And welcome to this webinar, U.S. Legal and Contract Considerations for a Post-COVID World. We're running this in cooperation with a local partner here in New York, Jonathan Sirota, who's the principal of Sirota Law Firm with a focus on entertainment, business, and technology. I, of course, am the U.S. Export Advisor for Enterprise Estonia, and we're also working on this in cooperation with Kairi Künka, who's on the line, who is the Consul General here in New York from Ministry of Foreign Affairs. So the webinar is going to be about an hour. We will spend about 40 minutes or so on the actual content. Please hold your questions until the end. I would like to just point out to everybody who is listening that if you scroll down on this page, you should see a place where you can submit a question specifically. Please put your questions there if possible, because when we then answer them at the end of the session in the dedicated Q&A portion, we'll be able to bookmark our responses for easy navigation later. And I would ask that everybody who is currently in the room and online, if they can just say hello or say that you can hear us and see the slide that is currently up on the screen in the chat box that you should find to the right side of your screen. So if everybody can just pop something in there right now to let us know that it is working and you are seeing everything as intended, that would be wonderful. Thank you, Tunnel. Michael, that okay? Hi. Hi, super. Okay, so it works. And with that, let's dig into it. So I would like to introduce myself. For those of you who don't know me, my name is James York. I'm the Director of U.S. Business and Innovation for Enterprise Estonia. I am based here in New York. I work from the Consulate General along with Kairi, and I am responsible for helping Estonian companies to enter the U.S. market and as well for helping to attract investment into the country. An important thing to know, if you haven't already interacted with me in a professional capacity, my door is always open, and I welcome any question from any Estonian company or entrepreneur. I am a resource for you here on the ground. Please use that, and feel free to reach out to me with any questions. If it is something that I can help you with, I absolutely will. And if it is something that I can't, I will hopefully be able to point you in the right direction. So with that, I will turn it over to the Consul General.
Hello, everybody. My name
hello.
is Kairi Künka, and I'm the Consul General of Estonia in New York. I have been in my post now the last 3 years, and the last 1 year I have worked closely together with James. I'm very happy that he's here now with us, and we are both. Our aim is to help you to enter to the US market, and my responsibility from the government side is to represent business diplomacy as much as we can. And just to repeat once again, our doors are always open. You have our contacts, emails, phone numbers, and please feel free to call. And hope to collaborate with you if needed. Thank you.
Good morning, ladies and gentlemen. I'm glad to be here. My name is Jonathan Sirota. I'm the founder of Sirota Law Firm and its principal. I would like to extend a lot of gratitude to Kairi and the consulate for having me here today. I'd like to wish everybody a healthy recovery and bounce back from COVID. I know it's difficult for everybody, and I think there's a light at the end of the tunnel now, which is uplifting. And a special thanks to Mr. York for always being a great resource for myself and my colleagues. James does more than I think anyone in the room realizes, and it really is bringing people together, making very valuable connections. With that said, allow me to introduce myself. If you can move to slide 5 today, you'll see the agenda. This is just provided so that you can navigate the slides after the webinar at your own convenience. If you're looking for something, it's the general order of our agenda. And moving to slide 6, a little bit about myself. I'm a New Yorker, born and raised in New York. I worked for many years for government ministries, businesses, and in major legal departments. 10 years ago, I started my own firm after having worked with famous brands, governments, corporations on projects across different cultures and around the world. That probably isn't a contract I haven't seen, read, or worked on. I'm a deal attorney. I focus on making deals. I focus on strategizing negotiation. I focus on making sure the intentions of the parties come together and the contract serves its higher purpose. We'll get into the purposes of the contracts during this presentation. But this presentation is going to be
I'm actually going to jump in
combination
there,
of
and
my
because I think that
observations
you neglected to
pre-COVID
mention a very
and
important fact.
post-COVID.
So
I
full
was a senior
disclosure to
executive
everyone
at the
listening,
Hearst Corporation
I
at Dow
previously worked
Jones.
with
I
Jonathan.
worked in
I was one
multi-million
of his
dollar
clients
deals
in a
across the
prior role
globe,
years ago
and
prior
I know
to
what works and doesn't
starting
work,
with Enterprise
not
Estonia.
because I'm brilliant, but
But when I
because I've
was
been
living
around
in Tallinn
brilliant
and
people my
looking
entire
to
career, and I
export
was
to
very
the
lucky
US.
to have a fantastic
So not only
journey.
is he
In addition to
is he
that,
an
I
expert and
have worked for the government
mastermind
of
in his field, in
Japan
my
and their
opinion,
ministry
but he
of
does also have practical hands-on
as a
experience
foreign
in some of the
advisor.
nuances navigating between
And I also went to
Estonian and
university
American
in
law.
Japan.
So very
So
important
having
to point
that
out for context,
cross-border
I think, as well.
international experience and the bilingual component really opened my eyes to different ways of contracting and different ways of seeing how laws, governments, and pieces of paper are supposed to support business, and that they're quite different when you cross borders. I'm also the founder of a debt fund working with international real estate investors, a PPE supply business, a fashion design and import business, and a Japanese manga publishing company. So as you can imagine, I've seen contracts of all shapes and sizes, and I've solved problems small to great, and it's just a lot of fun navigating from start to finish. So hopefully we'll have some fun today doing that. And lastly, I teach on faculty at the Practicing Law Institute, where I provide a legal education conference on complex licensing agreements. It's an annual seminar I do, so that's a lot of fun. So when you get me, you get the law and so much more in each client relationship. And now to the fun parts. Next slide, please. Thank you, Mr. York. I knew there was a reason why I invited you here today. I appreciate it. Well, thank you for that. It was a lot of fun and educational to learn so much about Estonia when I was working with James. He really, I'm a big proponent of telling people how technologically advanced Estonia is, how great easy it is to set up a bank account and a corporate visa. James has really educated me to be quite a proponent of promoting Estonia, and I didn't even realize it. So you did your job well, James. Now to the disclaimer. I put a smiley face here because we should smile when we see these things. They're here for a reason. They're not here because we're boring lawyers and we're scared of our own shadows. We're here because we perform a service. Our service is to make sure we give you tailored, specific legal advice to keep you in the safe harbor. Or at least if you go out into the wild ocean, we'll let you know when you're crossing that line into danger. And as a business person, you're allowed to take risk, but you should know it's coming. So disclaimer, this page is just to say, today's presentation is general in nature. Please don't rely on anything I say in this presentation or on the paper to make key business decisions. Reach out to your legal professional, talk to them, trust them. That's the best way to move forward. I'm licensed in the state of New York, and we'll get to a bit of the 50-state complexities of doing contracts in the United States, but I think most people on this call are already aware that America licenses its attorneys state by state. And of course, this is a form of attorney advertising. We're supposed to say that. So smiley face, next slide, please. So what is going on here? What are we going to do today? Today we're going to talk about what I was experiencing, doing, witnessing prior to COVID, and not immediately prior, but generally prior to COVID, with respect to commercial transactions, contracts, how international domestic companies were papering their deals, what the key decision makers are concerned about, where the emphasis was, and how sadly attorneys were being de-emphasized, and we'll talk about that a little bit. So before COVID-19 arrived, where were we? What was happening? What was my day like? Come into my office and you'll see what my day was like. Here we go. Before COVID-19, contracts were moving toward the light side of contracting. The definition of smooth operations, and we'll go through the bullet points in the slide, was to close the deal without a protracted legal discussion. The definition of efficiency and affordability, attorneys are very thorough and expensive. I don't know if that's efficient or affordable. Common sense, if it's not easily understood in the contract, a lawyer is probably over-lawyering the contract and holding up the transaction. There's no common sense if the business people could not immediately understand the clauses in the contract. What is progressive thinking before COVID? Well, business owners know how to make money. Attorneys know how to talk and write too much, but they don't generate revenue. Attorneys don't. Let's question and dismiss the advice of the legal experts to speed up the deal. That was progressive. The party of the first part and the party of the second part, hereby, these are old antiquated beginnings of contracts, very legalese. Contracts were trending away from formal academic approaches. Anything that sounded too legal, like the party of the first part and the party of the second part, nobody wanted to even see that. They said, get that out of the contract. So with taking out that specific formal legal language, you lose a little bit of the nuance. There's a reason why some of that legal language is there, and it's presented in the way it is. And you'll see it in a bit more when we come to force majeure clauses, why that's important. Next is agreeing to agree. Let's not fill up the contract with too many details or try to cover every contingency. Gosh, if that's not what a contract is for, I don't know what, but okay, let's not waste time in the contract to actually put in details and cover contingencies. We'll agree to work together to solve any problems that come along the way. That's a nice luxury in a pre-COVID, very wealthy, transaction-friendly and transaction-rich world. Speed to the deal. What does that mean? It's a covenant-light world. Covenants, the obligations in contracts, it's mostly seen in financing agreements. Covenants are the obligations that will trigger some events in contracts, rights, responsibilities, remedies. Pre-COVID transactional environment, we were moving towards covenant light contracts. Most companies were already using covenant light contracts, but they really thought they were using the standard document that everyone's using because they thought it covered everything. A lot of assumptions in the covenant light world. And companies place too much reliance on these contracts to protect them from future liabilities and contingencies. And that's what happened when COVID-19 arrived. You can imagine in the covenant light world, the first thing to go is the legal boilerplate. And I'll pause here just to repeat the word boilerplate. It's an expression. I feel that many of you may know this phrase, but think of it's the language that comes at the end of most contracts that just sounds like dense legalese, and it's not specifically geared towards the good or the service or the company. It just lives in every contract, and we call it boilerplate language. And if you want to know about the origin of that expression, I'm sure James can tell you that in a much concise, better way than I can. So moving on to the next slide. After COVID, what happened after COVID? Well, we have the same bullet points here, but somehow the results are different. What does smooth operations mean after COVID? Well, smooth operation. Whoa. I'm sorry. I apologize, folks. I was looking at the wrong screen. I have multiple screens in my office here. There we go. Thank you, James. You have the right slide up. Let me advance my presentation slide. Great. Post-COVID trends in commercial transactions. What happened here? Well, we have the same bullet points, but slightly different responses. How did the world change? Well, basically, they try to make everything the responsibility of the attorneys all of a sudden. Smooth operations. What does that mean now? Keep operations smooth. We better double check with our legal counsel. Make sure they take the time to identify unreasonable contract terms that either fail to or are attempting to address future occurrences similar to the 2020 COVID-19 event. What does that mean? I had somebody yesterday send me a new clause for a contract that they want to put in. There's a university doing a major software technology deal, and they told the software provider, we need you to add this to the contract. And I'm looking at this it's a whole page of language that basically says, if another COVID event occurs, the software technology solution provider must permit the university to pause the contract, must provide the services when and where the university says they want to restart the contract, must not charge any more fees, costs, or expenses, must. I'm looking at all this. I'm like, well, this is really one-sided logic. It doesn't share the risk of doing business in the world between two mature professional businesses. This just says, hey, if there's another COVID type of event, your entire business needs to bear the stress of that event. We don't want to spend an extra dime, and we want to get everything out of the contract as if the COVID event never occurred, when and if we tell you we want it. Now, as business people, we can't plan against that type of language. You don't know what your end liability and financial liability would be. You don't know your capabilities. This language was horrible, but that's what's happening. So for smooth operations, you'll start seeing a lot of COVID-specific language that is completely grounded in selfishness, illogical assumptions, and it does not provide a meaningful solution to preserve, and I'll say it again, to preserve the relationship of the parties. I've been contracting all my life. I've been doing deals all my life. I was lucky when I became an attorney, and I took my childhood skills of deal making into the professional world. It's just how I'm built. This is what I do. But to do a deal, it's a relationship. It's not about winning or losing. It's about allocating risks, and we'll see more in the presentation as we go forward. But these clauses that are coming out now are panicking, and they're pushing the allocation of the risk on the smaller party unfairly. So smooth operations means, well, how can you operate smoothly if you're going to have unfair restrictions or obligations placed on your business that are not priced into the deal? You must price these things into the deal. Sure, you want me to put all my people on hold to perform the service for you when and where you want it? Sure, no problem. But you know what? This deal is going to cost 10 times more because now our risk is 10 times greater. We've been pricing in these contingencies into our deals. And that's why, and people don't see this unless you're working at the highest level of contracting, the price of goods and services have become reduced because major players have agreed that certain risk and liabilities will not fall on either party. They'll fall in the middle, and each party has to absorb it or have insurance for it or realize it's their risk of doing business, but it's minimizing the liabilities of the parties so people can plan against that. That's why the pricing's come down. That's why the service is so quick, because everything is priced in and the liability is fairly allocated. So there's stability in planning in the future. So I won't stay on this slide too much longer, but I thought that was really important to share my point of view there. But watch out, these clauses are coming, and they're being drafted by the larger party, and they're being forced on the smaller party, and they're easy to push back against. However, pushing back against them is not about just saying no. It's about telling a better story. And I think we'll get to that in a few slides in. So next one is efficiency and affordability. I'm sorry, can we stay on the slide 9, please? So the next bullet point, efficiency and affordability. I'll go through this quickly. We want our attorneys to be thorough now. It's worth the extra time and expense to get ahead of any potential liabilities and contingencies. Common sense. Hey, we're not attorneys, we're business people. If you remember the previous slide, the common sense was, hey, we know how to make money, attorneys don't know how to make money. Now the common sense is, attorneys are very smart. Let's make this their responsibility. It's complex. Let's listen to them and maybe follow their advice. It's sometimes difficult to get them to follow my advice, but in the end, they realize that I know what I'm talking about. Next, progressive thinking. It's our attorney's responsibility to say and write everything that we need, all that legal stuff. So it used to be progressive thinking was, let's just say, but why do we need that to the attorney until the attorney gives up? Now progressive thinking is, we need more legal stuff in there. And what you're getting now with this so-called progressive thinking is these illogical, one-sided COVID clauses that parties are throwing at each other to shift liability. The party of the first part, the party of the second part, people want to see more formal language. It makes them feel more comfortable. Does it work? Well, we'll see with the force majeure clauses. It may look formal, but it may fail to serve its essential purpose. We have to make sure that these formal clauses are well fitted to the contract. Agreeing to agree. Now everybody wants to make sure contracts cover everything, every contingency. Well, that's an impossibility. It takes close working relationship between the business and legal side to see what contingencies are worth covering. Can't cover everything. What does this mean in the end? Covenant-heavy world. We're going back to a world where people want more in the contracts. The problem is, it's almost like losing the recipe to turn lead into gold. If you don't know that story, ask James about it. He'll tell you all about the journey of turning lead into gold. Many attorneys out there didn't grow up with covenant-heavy contracts, or they just didn't study hard at school. In America, to be an attorney, you just have to get 75% right on your exam. Boom, you're an attorney, which means probably like 25% of what you're hearing from your attorneys, there's a good chance that they're just wrong. That's a scary position to be in. Covenant-heavy world, it takes a lot of, it's like exercise. It takes a lot of training, weight training, to understand how to use these heavy covenants. It's not a skill for the non-informed novice attorney. You really need somebody who's lived and breathed these terms before. And yeah, maybe I spent too much time on this slide, but thanks, James, for keeping us here. Maybe we go to the next one. Okay, so federal and state governments during the COVID situation, what's going on? What are they doing to help businesses and contracts? Well, what's happening is the federal and state government is doing what they normally do. They are deferring to the courts. So let's see what we have here in the bullet points. First off, the media coverage and politics aside, in comparison to the 2008 financial crisis, the trend of the government policies have generally impressed most academics and professionals here in the U.S. It's been relatively quick and it's been relatively well-focused. But in the haste, there are always going to be mistakes. But generally, it's been good. We're doing a lot to support the economy, and supporting our economy hopefully will support the economies of nations around the world. Despite the political trends, America is connected and attached to international commerce very deeply. The government's intention to make aggressive and effective decisions, it's abundantly clear. It's just not that easy to get to the desired goal immediately. They may have to try more than once, but they're moving there. This goes beyond the topic of the presentation. The takeaway here is that the federal and state actions, they're largely aimed at preserving the status quo in the short term during the pandemic and fostering economic stability in the long term. They're not here as referees. They're not here to take problems away. In the consumer side of the world, and again, we're here talking about commercial transactions, contracting, consumer side of the world, there's some rescue clauses in there, but even those are temporary. There's going to be a bill to pay. You're not getting out of anything, and particularly in the commercial world, you're not getting out of anything. An example, recently, New York City was trying to pass.
And I'd actually like to just jump in on that. That's a broad
rule. I guess it was a city law. There's an
kind of
argument that it's
fundamental
not
understanding to
constitutional.
have about
But
the
the law
U.S.
basically
market
said
in general
that a
and how our
guarantor of a
bureaucracy and
commercial
how
lease
our systems are
or a
structured
commercial
here.
loan could not be
Obviously, we have laws. Our laws address
brought into court
many different
to
things.
pay
Our bureaucratic rules
payments
address
that
many
were being
different things,
filled
but
were failed to
there's
be made by
absolutely
the
a common
principal
thread throughout the entire country
tenant
where
or
you see
borrower,
that
and
everything
they're
is
just trying
written
to
in
say,
such a
okay, if
way
you can't
that
get the
the
tenant,
final
don't jump and
determination
get the
on anything
guarantor.
is very often left
Wait a
to
minute.
the
So this
final person
this
in
whole
the
rule
chain.
was
Right?
all
So whether it's
focused
a
on
judge or whether it's a
slowing
customs
things
officer
down because it
at
wasn't
JFK,
a
then you can come
perpetual
again.
change. It was only
The
during the
ultimate
pandemic.
decision
They're
on an
saying during the
individual
time of the
specific
pandemic,
case in front of
guarantors
someone
are being
usually
given
lies with
a
that
safe
individual.
harbor,
That's, I think,
but they're not
very
out of the
unique
storm. Once the
to the
pandemic's
U.S.
over,
market,
their guarantor
especially versus Europe.
status to pay the bills of the primary borrower or tenant
Well,
will
actually, John,
come back into effect. We're not sure how this is going to work out, but it does send a clear message to businesses. Figure out creative solutions. Don't go to court. We don't want you there. But if you do go to court, you could end up having your original obligations come back to life at the end of the pandemic. So you're not getting out of anything from any government action. What does the government expect? The federal and state governments, they expect businesses to work things out, landlords and tenants to work things out, commercial transaction parties to work things out. If not, you have to go to the courts. What we do here in the U.S. under our common law legal system is we make up all these laws and then we leave it to the courts to figure out how to enforce, and the courts have precedent. That's something that they have to rely upon here in the States, and we'll get to that in the next slide. Thanks, James. And that's a great segue to our next slide. Exactly. It's spot on. The judicial interpretation of contracts is something that requires attorneys to understand what judges have done before, not what the law says, but how the judges interpret the law, what's the trend. And these trends can turn around 180 degrees. There could be a major change. There could be two states with two different interpretations. Supreme Court comes with its clarifying interpretation, but that's for federal laws only. So the lay of the land here is you have to know the judges, you have to know the courts, you have to know the decisions. And the next slide, we talk about legal systems. The legal systems in the civil law country, a lot of my clients, I have a lot of international clients, they come from a civil law landscape. The judges can be part of the inquisitors during a trial. Here in the U.S., the judges don't get involved. They just listen. They don't act as part of the Inquisition. Civil law, it's not a case. It's a case-by-case basis. They're not looking at the previous decisions to guide the future decisions. Maybe in a certain sense, they all systems do that. But there is a adherence to the letter of the law in a civil law system that you don't find in a common law system. Common law systems, you can go outside of the written document. You can actually, the judges have great power to, I don't want to say ignore, but come up with a rationale why a certain law doesn't apply in a certain situation, but just for that particular instance. And the next case, if it's not exactly the same, the law will apply. And it's really knowing that finesse in the law makes all the difference. And a lot of my clients are surprised at how specialized attorneys are in the U.S. You know, I have clients who say, "You're an attorney, can you do this?" I'm like, "No, I don't do that." "But you're an attorney." Back home, all of our attorneys can do everything. Well, that's probably a mix of the systems are different, and also there probably are many more larger law firms in these foreign countries where they're full service firms. So it's not really their attorney doing everything. There's someone down the hall who does it. Their attorney puts their name on it. We have that here with our large firms, but with that become large legal fees. It's a very expensive relationship to maintain. U.S. has a lot of specialized legal counsel that really focus on a narrow area of expertise, and with that, you're getting, going back to the judicial interpretation, you're getting that finesse of knowing what the judges are thinking, knowing where the legal trends are going, knowing what trends are about to end. It's very important to know that certain interpretations of these contracts are falling in disfavor. We have 50 states, and as these states start coming out with a newer interpretation, it's a 50-50 timing issue of when and if that interpretation will now come to your state, or unless the Supreme Court gets involved. And that's another conversation that's beyond this presentation, but I gave you a link to Wikipedia if you're curious about the differences in the judge-made decisional law that we have here in the U.S. versus some other laws in Europe that have a much more core principle letter of the law system. Maybe go to the next slide, please.
I know that I'm going against my
Okay,
own,
that said, we do have some standard
rules, but
industry
I'd actually
agreements.
like to ask a question.
So
Just
we're not
said that the
exactly
UCC applies if an
just
Estonian company is
making guesses in the
transacting
dark.
through a
We have
subsidiary.
something
But
called
what if they're
the
transacting
Uniform
directly
Commercial
without a
Code.
U.S. presence?
As you can see, I took this from Wikipedia. You can go back and read it on your own. It's just basically for the sale of goods, not for the sale of services. So if you're selling goods, the UCC will apply. In some instances, for technology and software, it will apply. The UCC is a response to companies using purchase orders as opposed to formal agreements to transact business. The UCC is a very detailed document that has contingencies for almost every single type of instance that may arise with the sale of goods. It's very helpful to know about the UCC in the event you're working through a U.S. subsidiary of your company and you're actually transacting as a U.S.-based business with a U.S. company. Each of the 50 states needs to adopt this separately. And when they adopt it, guess what they do? They make changes. So not every UCC in every state is the same. It's a very complicated system. And there are portions of the UCC that have been adopted that also allow for those sections to be modified. So you can adhere to the UCC for the sale of goods, and then you can modify the sections by the contract, or you can just say in the contract the UCC does not apply. There's no mandatory application of the UCC in the event the parties agree it will not apply. If you fail to address it in your contract, whether it applies or not, then it may very well apply, depending on the state law. Moving to the next slide. I'm glad you asked that, James, because we have some more letters of the alphabet to share with you. Can you move to the next slide, please? And here we have the CISG, or as I mistakenly write it all the time as CIGS. James caught that. Thank you, James, for fixing that for me. United Nations Convention on Contracts for the International Sale of Goods. Stop, breathe. Whew, that's long. Okay, UN is really good at having long titles to things. They're amazing. So now we have the situation where the US, 93 countries and counting, have ratified this CISG, which again, it's like the UCC, it's a suggested framework for the situation when an international entity is doing business with a domestic entity that is a contracting state. So it's very similar to the UCC in the fact that it covers the sale of goods and the fact that it has default resolution and procedures. And if you are dealing in the sale of goods, it's very important to get to know this. It could be your friend. I was on a case, very important case where I'm not going to say my client was wrong, but let's say the other party was supposed to do something according to the UCC. They failed to do it. So it doesn't matter whether my client was right or wrong in the failure to adhere to the black letter of the law. Now, going back to the civil law systems, that black letter of the law is so important. It's not a judicial interpretation. The UCC has certain things that a party must do in order to enforce its claim against another party, and the other party deprived my client of its ability to get the economic benefits of resolving the problem. One company cannot get all the economic benefits. There has to be a balance, and there was a requirement in the UCC for a party to preserve inventory in a safe manner for resale so that they can liquidate it and cover part of the damages. They just threw the inventory out, destroyed it. And that alone, the judge said, you didn't preserve the inventory. UCC requires you to preserve it in a warehouse and protect it and insure it. And you can charge it back to the other party, but you have to do it. And these mandatory requirements, we're not used to that in the States. UCC has it, CISG has it, but again, most of my clients, when they are doing international agreements, at the end of the contract, we add a clause that says, oh, by the way, the CISG doesn't apply to this contract at all. Is that smart? Is it not smart? The devil's in the details. It really depends on the nature of your business and how you transact business. But this is a case of where things are really set in stone. And you have to, these are really complicated documents. You need to have a good team involved with this. And it does cover the type of force majeure events. We'll see later on a common defense that arises from UCC or CISG types of events when something like COVID arises. We'll get to that in a later slide. But I wanted to introduce these frameworks to you. The last one is of these examples, move to the next slide, please, is very subtle. We call it CBA, collective bargaining agreements. Collective bargaining agreement, they're union agreements. I know Europe has them as well. And these agreements set out the minimal level of requirements for contracting with certain parties, whether it's the union electrician, truck driver, warehouse worker, loaders, unloaders, whoever you're dealing with, to the famous directors and movie stars. I did a deal with a Victoria's Secrets model where she was starring in a laundry detergent commercial, and the international company that hired her to do it, they're shooting in LA and in New York. They were trying to impose their domestic contract for talent, and it just wouldn't fly in the US. It's not a matter of the laws of the Supreme Court or the laws of New York or California. It's the collective bargaining agreement. This individual cannot contract outside of these parameters. So no matter what you look at, it doesn't matter if you don't know what the collective bargaining agreement says. So in transactions, we need to see what type of unions are involved. And also there are some labor laws. It's beyond the scope of this conversation. There's some labor laws that may also be triggered, but that's something that we can get to on a case-by-case basis outside of this conversation. But collective bargaining agreements are very powerful in the US, and we have to abide by them. And we have to build that into our contracting if it comes up. Great. So next slide, please. So question I'm asked all the time, and as I mentioned, I actually teach other attorneys on an annual continuing legal education seminar as a faculty member. Been doing it for quite a number of years. People want to know whether or not what I do is an art or a skill. Is contract law an art or a skill? Everyone's asking me for the template. Everyone wants to know. I have attorney colleagues who ask me, hey, Sirota, do you have a template for XYZ? I said, I have 20 templates for that, but I don't use any of them. I kind of mix and match them and add my own language depending on the transaction, because you have to really feel the nature of the business risk allocation. You have to know your industry. Like, yeah, but just give me a standard contract. Well, are there a lot of standard form contracts out there that purport to answer all problems, address all problems? Yes, there are. Are they actually standard? No, they're not. I received a contract from a party in England, and under the law
I'd
of
actually
UK
like
and
to
Wales,
piggyback a comment on top of
England,
that.
under the law of England and Wales,
And
they said
it's
this is our
mostly,
standard contract. I looked at it. It
and
was a
I
Mickey
say
Mouse
this as
contract.
I come from
It
the
was from
community,
some trade union
so I
that
say
everyone
it
just
with love.
agrees to
But
use
very
because
often,
they don't want
especially in
to actually
startups, and it's
think
not just
deeper.
exclusive to Estonian startups, it's a problem with
So
startups
what
everywhere.
is going on here? Is
Very
it an art
often
or a
because
skill?
of
Well, the answer
lack
is
of
it's both,
funding,
obviously.
time,
Whether it's a
resources,
common law system or a civil
experience,
law
all
system,
of it.
we all have to learn skills and
Young
techniques.
companies will very
We have
often
to
just go and
absorb from our senior
other
attorneys over time
companies'
and gain
legal
practical
documents that they can access
experience.
online,
Again, the U.S.
assuming that
attorneys are
the
super,
boilerplate language
super
that is there
specialized. I have
will
clients
suffice
from
and offer
Asia
them
who
some
just
level of
can't get their heads
protection.
around that. They don't understand.
In
The
a
law is the
market like
law.
the
It doesn't
US, where
matter. I
everything
should be able to do it.
is
If I
so
can do a contract,
subjective,
I can do
when you
an
finally
adoption
get
or a
down to
criminal
the
law,
nuts and
or
bolts of it
I
and
can't.
the
It's not what
actual
I do.
decision,
It's
the
a very
final
deep,
decision,
different
I
area
can't
of the
stress enough
law.
how important it is to not do that, and really make sure that the contractual documents that are supporting your business are tailored to your business. Because if you're just using borrowed language, let's say, you could find yourself with some blind spots that you had no idea were there. A lot of information and really, really useful.
Thank you, James. And that's very true. The hardest part of my job is not explaining to my clients what the contract says. The hardest part is explaining to them what it should say, but it's not saying. What's missing from the page. Because if they don't see it, it's not real to them. And that's really scary. And starting this presentation, we spoke about covenant heavy versus covenant light contracts. And we're going back towards people asking for more legal language rather than less. So hopefully that trend will continue for the benefit of not just, I guess, it's continued employment for attorneys, but it's also a safe harbor, and it serves the client very well in the end. It supports their business, and it's think of it as fertilizer for the garden to help the flowers grow. I just call myself fertilizer. Interesting. Moving on to the second part of the slide is art of law. So is it a skill or is it an art? Well, we know not everyone can dance, sing, act, perform magic tricks with the same level of talent. There's a limit, but there's a limit to what can be learned versus natural talent. And when COVID-19 contingencies arose, business owners started to realize whether or not their attorney knew what they were doing and was able to take charge, keep the situation calm, come up with solutions, not idiotic, illogical boilerplate that unfairly shifts the risk to the other party that the other party's attorney will have to push back against. That's not a solution. If I send out a document, I know the other attorney is going to have to push back and redline. I'm not helping my client. We're not finding that sweet spot of relationship building. And that's the part most attorneys don't have in the art, is relationship building, putting in solutions, putting in more information in the contract that will tell a story. And that's why good attorneys tell stories in their drafting. And the last bullet point here, attorneys drafting contracts are always aiming to pace or stay ahead of the trends in judicial interpretation of the written laws, which differ from state to state and with federal law. It's critical to view the transaction with an artist's eye, to add non-statutory language. I always get this. I said, we don't need that in the contract. Why is it in there? I said, trust me, it's going to be helpful. This is for the judge who's going to read it down the road. Very helpful. People come back to me years later and say, oh, now I know why we had that. I'm glad we had that language. Tell a convincing story to the court, but also tell a story to the contracting parties so they know their positions on the stage when trouble starts. They know what their obligations are. If you don't put it in the contract, they're just going to point fingers at each other. And the contract is not living up to its higher level of service, which is to provide stability of the relationship and opportunities in case contingencies arise. So the attorneys who have this natural talent, and there's a bunch of them out there. I teach with a lot of them. You know, their contracts are just fun to read because it's like a movie script. Not only when you read something, you're like, I knew that was going to come. That's great. I get it. Now I see how this relationship is shaped. Let's go to the next slide. Okay. So this is where the fun begins. You did all your homework. Everything up until now was eating your vegetables. Now I'm going to give you dessert. This is what you're here for. What does this all mean? It means it's complicated. 50 states, federal laws, CISG, UCC, ABZ, AXYZ. It's so much. And all the terms could be nullified, modified, changed. What's happening here? And COVID-19 is causing companies to illogically shift the burden risk of loss to the other party to make it just unreasonable for them to do business together. A second wave is probably going to come. Hopefully it's not as bad. But if it's not COVID-19, it could be something else. So we need to get smarter and get ahead of these problems. We need to tell stories that speak to the prevailing judicial trends and to the other parties so they know what to do. The answer is it's complicated, but not unreasonably complicated. If you just add a little more effort to your contracts. Okay, so going through slide 16, 17, what were we? We're 17, yes. Okay, so yeah, skip 17, that's a duplicate slide, sorry about that. 18, okay, so what kind of contracts are there? We have letters of intent, which you probably have seen, some with NDAs, some without NDAs, some with non-circumvention, NCP, non-circumvention provision. Letters of intent, that's when you're starting to engage with somebody. You want a letter of intent. Most of them are not enforceable, but with these letters of intent, it's usually very much a standstill letter so parties can do business together, can start to see if they can do business together. Then you have purchase orders. You're actually buying and selling something. Some with standard terms and conditions. Some simply rely on the CISG or the UCC. We need to understand, is COVID covered by these? Is the UCC or CISG, is that adequate to cover COVID contingencies? Let's look at what you're using. Purchase orders are usually just bills of sale. They're not very useful usually. Memorandums of understanding. Memorandums of understanding are really, really tricky because they can almost be a formal contract or they can almost be a purchase order. They can be on either end of the spectrum. Memorandums of understanding usually have less boilerplate legalese, the type of language that everyone is relying upon to help them in the COVID type of situation. I more or less guarantee you those are absent from your memorandums of understanding. So what we need to do, even in the basic sense, is revisit our memorandum of understanding and see, do we need to add any COVID-specific language to that memorandum? And the answer is going to be yes. I can almost guarantee it. Then you have the formal agreement, which could be a single transaction or a master agreement for multiple goods or service transactions. Those are fun. Those are long. I get to draft and say a lot. Beautiful clauses in there, but are they the right clauses? Or you have no contract whatsoever. And a lot of people just do a handshake and somehow it all works out. Crazy, but true. So the answer is we just need to make sure you're using the right type of contract. And also these contracts that don't usually have COVID related provisions, we have to start putting them in a manner that's fair and reasonable to the parties. Next slide, please. So what are companies doing? Companies are looking at force majeure, which I think many people know. That's the unforeseeable event beyond the control of the parties. Representations and warranties. You represent and you warrant, you're going to follow all COVID preventive measures. Well, what does that even mean? I've seen that. Follow all COVID preventive measures. I don't know what that means. Indemnification. It's your fault if someone gets sick or the project doesn't go right. These are not solutions. These are force majeure, by the way, is a temporary. We'll get to that in another slide. It's a temporary fix. Representations and warranties, that's just finger pointing unless we know what the standards are. I don't know how to live up to a lot of these representations and warranties. I'm seeing them. They're very illogical and unfair. These are all the new COVID reps and warranties. Indemnifications, again, listen, if I can't insure myself and you can't insure against it, why should I suffer the risk of loss if nobody has insurance against this? So that's the insurance clause. And then limits on liability. Okay, let's just say I'm liable for everything. My liability is not going to be above a certain amount. These are not answers. These are safety nets when you're falling off a mountain to catch you. The boat is sinking. You're in a raft floating in the water. You're alive, but didn't save the deal. These are very important, but they need to be drafted carefully and in tandem with telling the story. Remember, none of these common responses, you're going to see a lot of these. This is where you're going to get all the changes in your contracts with your contracting parties. They're all going to come through these doors, and they're not going to be responsive to telling the story of how can we save the relationship? What can we do to navigate future COVID events? Next slide, please. So here we I think I just covered this. Yeah, so catch-all. This is just more for you to read after the presentation. Just talks more about what I just said about over-relying upon these boilerplate language. Next slide, please. Okay, so our company's placing too much faith in the safe harbor of force majeure. Absolutely. Force majeure clauses are only temporary in effect. Unless your force majeure clauses has a termination provision, which most do not. Many force majeure clauses, they must be so specifically drafted as to not apply to the COVID. Right now, most force majeure contracts clauses do not have pandemics, epidemics, riots, civil strife. They don't have these things written there. And if it's not written there, the courts are not going to enforce it. And if the courts enforce it, once the situation is over, your obligations come back. So what does the force majeure clause really give you? It's not a solution. And it's very, very narrowly tailored. And a lot of force majeure clauses, as commercial tenants are realizing, and some commercial transaction contracts as well, say everything is suspended but your obligation to pay. You've got money in the bank, you've got to pay. So the whole cash flow issue becomes a problem. You read through the slide. We can talk about this after the seminar. Force majeure clauses are really not what they seem to be. They're not the panacea. And I would also argue, although you can shoehorn in pandemics as a force majeure, I would argue that COVID is no longer unforeseeable. Definitely beyond the control of the parties, but no longer unforeseeable. So next slide, please. So now we're looking at some other common law. I'd mentioned that the UCC has a defense as well. These, again, if you are at this point in the relationship, your deal has failed. Your relationship has failed. Your contract was not drafted for the contingencies. These are when people forget to draft things into the contract, or if something very unforeseeable does occur. So you have failure of consideration, impracticability, impossibility, frustration of purpose. None of these are solutions. I gave this to you to read, and maybe your attorneys can look at it. Just give you some of the vernacular that's being thrown around the courts today. Every day I'm reading legal articles on these issues. This is what people are relying upon because they have not drafted their contract properly. Next slide, please. Okay, so what do we have here? Let's talk about the next generation of contracts. Next generation of contracts, it's going to take some work. It's going to take some thought. You need to understand your business better than you understand it now. If you understand your business, it's all going to make sense to you. So we have to go through a checklist with your attorney and sit down and say, what are the performance obligations of each party in the event COVID-19 situation reoccurs? What are the standards of care? What will show that I did what I was supposed to do, even if it fails? Because we can't control pandemics. Let's build those into the contracts. Risk of doing business. What can be insured? What cannot be insured? If it cannot be insured, should I absorb the risk? Should it be the other side? And can we cap it at a certain monetary amount? Maybe that's what you do. You cap it. Notice requirements. When does a party have to tell me that they know they're not going to meet their performance deadline? I need to plan ahead. And this is what happened a lot. A lot of force majeure clauses failed in a lot of cases because the force majeure clause required notice as soon as reasonably able by the party affected, and they didn't give notice. And when they didn't give notice, they try to rely on force majeure. It failed for them. These are the little details we have to build in. Meeting requirements. Should we get the C-suite or the CEOs of the companies together as a precursor to any legal actions for a case of a COVID event, how we're going to reconstitute the relationship? U.S. companies won't do that unless it's in the contract. If it's in the contract, it's beautiful. They do it. It works. It's got to be in the contract. I've seen it happen. Suspension formula. If your performance delivery is suspended, how does that work? What we have to wait for the WHO to say pandemic? Can we do it early? Can we build in a suspension clause? I have it in my contracts. Not all of them, but some of them we can suspend under certain circumstances. And then contingent liabilities. Are you really addressing all the contingent liabilities? Let's sit down and think about it. People are not thinking. You just have to be a little bit slower and think about it. Talk to your attorneys. Additional insured. Every insurance policy here in the U.S. has the option of allowing the other contracting party who has a risk of loss to be added to the party of the first part, if you will, insurance. So you may not be able to get insurance yourself, but ask the other party, can you add me to your insurance policy? The question is, will their insurance policy cover COVID? They probably don't even know. So you probably have to get a copy of that and show it to your insurance reviewer or attorney. Reperformance, redelivery. Okay, what's happening now? People are all paused. They're still liable the moment the pause ends, the COVID pause ends. They have failed. They've missed their deadlines. They've missed their dates. What happens? Reperform, redeliver, build it into your contract. Very important. Termination fee. Let's say you can't reperform, redeliver. Let's build in a termination fee that's 30% of the scheduled contract price. You know what? You can cap your liability. At least it's a moving target. So the closer you get to the end of the contract, the lower the termination fee would be. But you can just get out of any type of legal obligation. You can exit the contract. That is not in most contracts. Sometimes the termination fee can be, next slide, please. Sometimes the termination fee can be part of the built into force majeure events only. Maybe it doesn't live in the main contract, but in the event of force majeure, you can terminate, and there's a termination fee there. Going to the top of this slide, escrow payments. If you're putting money in a third-party escrow to cover the cost of your transaction, make sure that escrow agreement has COVID-19 instructions or pandemic instructions. Most escrow payments are stalled and they're being held by third parties because there's nothing to address the force majeure situation. Personal guarantors, there are a lot of new companies springing up in the US, people who just taking advantage of opportunities, but there's no track record for these companies. They're springing up left and right, and we don't know if they have any credit worthiness. Get personal guarantors, get the owners to be a personal guarantor. There are many ways of doing that that are not unfair, not onerous. The liquidated damages, the US does not allow penalties. You cannot penalize a party in a contract law, but you can have liquidated damages if the type of damage is very hard to calculate. The courts, remember I said tell a story? The courts want to read in the contract, not that there's force majeure, they want to read that you thought about this. You have a termination fee, you have liquidated damages, you have reperform, redeliver. You have a way to address how do you recover from force majeure. That's what the courts want to read. They want to read, maybe it's a sliding scale, maybe your delivery volume obligations, your service timing obligations, they all get extended or they all get somehow rebalanced based upon what your supply chain will give you. Maybe it's not force majeure. Maybe you have a clause in your agreement that says my supply chain will only give me X volume of materials. And if I don't have this item, this screw, this nut, this transistor, I can't deliver my goods. Well, that's a supply chain problem. And let's make sure it's built into the contract so it gives you more time to either extend performance, get out of the contract, or just change the deliverables. And of course, as price changes and fluctuate, these price changes need to be built in. If we see a COVID pandemic price change fluctuations in goods and services, if you learned that about your industry now, let's build it into the contract. I do it all the time with my hospitality service agreements for food and beverages when the commodity prices change. That's very common. A lot of this is old school lawyering. And the last two slides, the last 2 points here, force majeure, does it talk about how the party's going to restart their relationship and measure the performance following the force majeure? Let's build that in. Yes, it's going to take another page, but that's a good page to have. A lot of people didn't have that page and they were caught in a very bad situation. And lastly, the UCC and CISG. In the case of sales of goods, you want to make sure that you exclude them or include them, but make a decision. Go one way or the other. And if you include them, you can modify some of the concepts. Next slide, please. And in closing, what do businesses need to do for their next generation commercial contracts? Of course, you need the boilerplate, but make sure the boilerplate is reviewed and improved, because the boilerplate, the force majeures clauses now, a lot of them are failing. They're just not working. But we need to tell stories. We need to make sure that the contract tells us stories of how the relationship is going to respond to these fluctuations of the economy and nations and health. We just need to get ahead of it and make sure it's fair, not illogical or imbalanced. Speak to your attorneys, come up with creative solutions. Courts love contracts that give them the direction. You don't even have to be completely on point and super detailed. As long as you show the court the intention of the parties were to go in a direction of compromise, and it's in the contract in a formulaic way, not an aspirational way. And this is the last thing I'll say. Don't put aspirations in your contracts. Put formulas, put certainty, put clarity. Courts love enforcing that, and that will also prevent them from taking you to court in the first place. And they'll sit at the conference room table and they'll talk through the issue. So reach out to your legal counsel. Don't think that your current clauses actually serve the purpose they were intended to serve, not just because of COVID, but because we were in a covenant-light world before and people had a false sense of security from underdrafted, improperly fit legal clauses that they just live with. And I'm always around if you need to chit chat. Always happy to help out my friends at the consulate. And James, I'll give the floor back to you. Thank you for
and
the
handy.
time.
So thank you for that. We're now going to open it up. We're running a little bit over, and the Consul General is having technical problems, so I don't think she is with us anymore. But if you have questions for either myself or for Jonathan, now is the time. And I see that Arne has one in the chat, so I'm going to read it out loud. And Jonathan, if you can take it. So for all the talk, is it inexceptionally about focusing on final product marketing and sales, or can you go from invention to prototyping businesses ready for incubation on a TRL1 to TRL3 scale? I'm sorry, I'm not familiar with that scale. And can it be brought in for facing IPR issues, including branding concerns? I think so as well. I think so.
My gut tells me this is probably
it's
a
quite
question
specific,
that
but I'm very
James and I
happy.
can follow up with you after the presentation. Yeah.
Yeah, Arne, I will.
Yeah,
I'll
be
pass
glad
your
to.
contact
I'll be
information
glad to
to
follow
Jonathan, and he
up.
can reach
James,
out.
can you set that up?
Does anybody else have any questions while we have Jonathan on the line?
And if not now, feel free to follow up through James or directly to me. Always happy to lend a hand The direction ahead shouldn't be complicated, but it just will take a little extra work and effort in thinking about business solutions and telling a story of what the parties want the relationship to look like in the event things get
if nobody
difficult.
else has any questions, as
We
we
know
are a
what it
little bit
looks like
over,
when things are easy.
I will close out the session. Jonathan, thank you so much. Kairi, I don't think you're in the room, but thank you as well so much. And we will be sending out automatically through this platform slide replay, webinar replays, and I will be sending out personally to everybody who's registered a copy of Jonathan's slides along with a video replay that is accessible on YouTube, so you can share it widely with colleagues who may not have had time to register for this session. So with that, I want to wish everyone a very good evening, and thank you for joining us.
Thank you, everybody. Have a great one.